Hello, Dominionaires and our kingdom builders. This is Tally Carter, and we're in week 22. And this week, we're focusing on protecting your ideas. Our scripture is from Proverbs, the fourth chapter, and the 23rd verse. And this is a little different. It says, above all else, guard your heart, for everything you do flows from it. I know. What does that have to do with protecting your ideas? Well, I want to talk to you about conversations that I've had more times than I can count, really. Even with different founders and in different industries. Nevertheless, it still comes down to the same thing. A founder builds something genuinely original, whether it's a framework, a curriculum, a signature methodology that took years of experience and reflection to develop. They share it generously. They share it in a workshop, they share it at a free training, they have a conversation with someone that they didn't know necessarily that they were trustworthy or not, or they even sent proposals out to potential partners who ultimately told them no. And then months later, they encounter some version of it, whether it could be repackaged, renamed, and is being taught by someone else as though it was original to them. Of course, the founders, they're devastated. And in nearly every case, when I asked what protective steps were in place before the sharing happened, before they started giving things away, the answer is always none. There was no confidentiality agreement, no documentation establishing when they created the thing, no registration and or no copyright filing, nothing that would allow them to assert legal standing that the work was theirs first. Our scripture, Proverbs 4 and 23, instructs us to guard our hearts above all else because everything flows from them. I want you to apply that to being a kingdom builder. What flows from your heart through your mind into tangible form? That's your ideas, your methods, your creative work deserves the same intentional guarding. What you do not protect, you risk losing. Not because the world is uniquely hostile, but because ideas without protection, practically speaking, are up for grabs for anyone. So we want to be real specific here, especially in this community, because often in the culture that you're building in, there's certain vulnerabilities that I see around this topic. There is generosity that runs through kingdom-minded communities that is genuinely beautiful. Love it. It's a posture of giving freely, sharing openly, believing that abundance multiplies when it is released rather than guarded. That posture reflects real spiritual truth. Generosity is a kingdom value. And hoarding insight, hoarding your ideas out of fear is not the standard that we are called to. But that same generosity without discernment can create founders who give away their most valuable intellectual property before they build any infrastructure to protect it. The instinct to share freely is good. The absence of any protective wisdom around that sharing is not generosity. It is an unguarded heart. And it's specifically what we're talking about in our scripture, Proverbs 4:23. That's what it's warning us about. Guarding your heart does not mean withholding generosity. It means being wise about what you share, with whom you share it, and under what protective measures so that your generosity can continue to flow without leaving you exposed to having your work claimed by someone else as their own. You can be generous and protective at the same time. They're not opposites. They just require different kinds of intentionality operating at the same time. So I want to get technical with you because I do think there are some things that you need to have an understanding in. Intellectual property law is a broad field, but for the purposes of early stage kingdom founders, there are a few categories that it's worthwhile for you to understand clearly. Okay, copyright protects creative works. That's your written content, your course curriculum, videos, design, original artistic or instructional materials, anything that you create. The significant thing to understand is that copyright protection, it is actually automatic the the moment you create the work in a tangible form. Because how it begins is you create the work in your mind, but then we have to get it out of your mind and onto a tangible form, whether that's a piece of paper or a memory stick, something that we can pass to another person. And so you don't have to file anything to have copyright protection. However, here in the United States, registering your copyright at the US Copyright Office gives you something that automatic protection does not. By registering it, you have the automatic legal standing to sue. So if someone infringes on your work, meaning they take your work and use it as their own, without having an actual registration of that copyright, you can still claim ownership, but it's pursuing, legal remedies becomes very challenged. So registration is the first step. Trademark, on the other hand, protects brand identities. So it's all of your brand identifiers, your business name, your logo, your taglines, anything that identifies the source of the good or services back to you in the marketplace. So unlike copyright, trademark protection generally requires registration from the jump in order for it to be enforceable at the level that most businesses need. So if you want protection beyond your basic geographical area, you're going to need to register your trademark. A trade secret is different than a trademark. A trade secret protects confidential business information. So that would be your proprietary methodology, your secret recipe, your client list, your internal processes, anything that has commercial value, specifically because it's not publicly known. So a trade secret protects those things that you are keeping private from the public. Now, this protection only exists as long as you actively keep that information confidential. So you have to be persistent to make sure that that information is not getting exposed to the public. You have to protect it. But the moment that you share it without protective measures, then that trade secret status can be lost. So that's precisely why we use confidentiality agreements, because this is the way that we protect your methodology, even when you need to share it with another party. But now we have put some measures around it so that the other party knows that this is valuable and to be kept secret. Patents protect inventions. That means new processes, machines, equipment, technical innovations. And patents, this is the most complex and expensive form of protection. And it is the one that most early stage service based founders probably won't need. But if you have developed something novel, something that has a genuinely a technical invention, rather than say a methodology or a curriculum, uh, if you created something that's technical and design oriented, then that's something that you should absolutely sit down and have a discussion with an attorney about. Okay. But for most of you who are in service-oriented businesses, you have or content creators, or you are selling a product, probably not going to need patents. You're most likely you're going to need copyright protection and trademark protections first and foremost. And so trade secret protection matters than anything proprietary, like if you have a client list or you have a specific method in the way that internally you do business that is your secret sauce, then trade secret protection is something that you may need as you grow. So I do want to focus on that practical tool that I think everyone at this stage needs to develop and create the habit and discipline of using all the time. And it is pretty simple. Before you share proprietary curriculum, your signature framework, your unique methodology, or any other confidential business information, either with a contractor, a potential collaborator, a prospective business partner, or anyone outside of your immediate team, I want you to have them sign a confidentiality agreement. Commonly, we call it an NDA or a non-disclosure agreement. Now, this document, it does several things at once, and so it's pretty important. It puts the other party on formal notice that what you are sharing is confidential and proprietary. So this establishes that you treated the information as a protected trade secret, and a requirement if you ever need to enforce it later on, we need to have this in place. And also, having an NDA creates a deterrent because most people are considerably less likely to misuse or misappropriate something that they have formally agreed in writing not to use or disclose. And thirdly, it gives you the legal recourse if the agreement is ever violated. That's the basis to pursue any legal remedies if you have this NDA in place. So a basic one-page NDA, it's not expensive to create. It does not require a lengthy negotiation, usually not at the early stages of a business, but it does require discipline to use it consistently. I mean it. Every time, with every party, no matter how close you think you are with someone who's outside of your business, um, you're hiring an independent contractor, have them sign an NDA before you start sharing information about your business. Now, um, there is some you don't have to be quite what would I say? You don't have to be paranoid. You don't have to be paranoid about it because for the most part, your friend circle probably doesn't have the uh capacity to be able to take your idea and run with it. But if you are starting to deal with people who are a little bit more established than you, then yes, you're probably going to, you have a greater risk with them because they're already at a place and have the means to take your idea and do something with it more substantial. So you can balance it, but I prefer that you just develop the habit of doing it consistently every single time. And then that way you don't have to second guess whether should I do it this time or not. Just do it. So just make having an NDA standard practice now before you need it, because the cost of asking someone to sign an NDA is really just a small matter of friction, and most professionals expect it anyway. But the cost of not asking it in some cases can really be a loss, a great loss as you build. So we want to develop that habit now. Now, I do want to close with something that connects back to our theme, and we visited this before in the series, but it bears repeating in this context this week. Every time you write down your methodology, date it and store it in a document, in an email to yourself, a dated file, something. Just create evidence of origination. Because if a dispute does ever arise over who developed the idea or the framework first, you have a documented, dated record that is often helps in the deciding factor. So this is not about distrust. Again, this is about wisdom as our scripture connects guarding your heart to everything that flows from it. And what flows from your heart through years of experience, prayer, reflection, into the content that you're delivering, the methodology that you're implementing, the framework that you're teaching, it's worth the simple discipline of writing it down, dating it, and keeping a record. You do not need to treat every idea as a secret to be hoarded. That's not what I mean. But you do need to treat your most valuable intellectual property, that's the thing that took real time to create and produce, the real insight that you have developed. You need to have the protective wisdom that ensures your generosity and sharing remains a choice you are making rather than a vulnerability that someone else can exploit. So guard what flows from you. Not because the world is your enemy, we're not looking for enemies, but because what God has entrusted to you to help build his kingdom requires us to have intentional stewardship. As everything else that we've talked about this year, we are stewarding the vision that God has given us, and that means we have to protect it. All right. So this week in our reflection, I want you to think about what is your most valuable piece of intellectual property? What is it in your business right now, and how is it protected? We're going to name it specifically. Do you have a framework? Do you have a secret recipe? Do you have a curriculum? Do you have a brand name, which you should have? Do you have a logo? Do you have a piece of original content? Then ask honestly, have you registered it? Have you documented it? Have you required confidentiality agreements before sharing it with people who could potentially take it and use it? If the answer is no, which I'm certain it probably is no, this is the week we want to address that. We want to fill that gap this week. So let's get it done. And then also, now I don't want you to get frantic, but I do want you to consider, have you shared anything that's proprietary recently without taking the protective measures like an NDA? And what would it look like if you build the habit of always using an NDA in your business operations? This is not about, I don't want you to be frantic and regret anything that you've already sent out, but I do want you to think about implementing a discipline process in the way you carry out your business, that this is automatic in how you protect it. And so we want to create the discipline of guarding what flows from you before you release it out to the public. Whether you're talking to a potential partner, you're talking to an independent contractor that you're hiring, a vendor, we consider their capacity to be able to misuse or misappropriate what you're creating. And so we want to have the discipline of protecting it before we share it. So generosity and protection are not opposites. Guard what flows from your heart. And so we want you to be able to give away, but we want to give it away on our terms and for as long as God has given you to give it. So there's a stewardship level to being generous. So, is there something that you built that you have not protected, something that you created that you have not guarded? Hit me up in the comments. Let me know what's going on. And of course, I am happy to help in any way. And even if you just want to talk something through, because whether it's an NDA or a copyright registration or a trademark registration, or just what's the practice of documenting your creations. We want to work on that this week, and I'm happy to help in any way. And so, as your executive counsel, and we do want to share a tip or two this week. Tip number one, we talked about the four main types of intellectual property protection that every founder and leader and entrepreneur needs to understand, whether that's copyright, trademarks, trade secret protection, or patent protections. Every early stage founder needs to at least copyright and trademark your most valuable intellectual property straight away. Now, copyright protection does to have the legal standing to pursue legal remedies, you're going to need to register that with the U.S. Copyright Office. I know we've covered this in the past, but I want to bring it back to your attention now that we're a few more weeks into the process of launching your business. So we don't want to lose track of that. And so now is the time to relook at what you've been creating, and let's make sure that we get it registered. And so by now, you probably have a brand name, you probably have a logo, and other identifying marks to your brand. And so you need to register those with the trademark office. And you need to register it federally in order to have a federal registration, meaning to cover all the United States. You have to do several of them. So now is the time to make sure that you do those two steps. And because we want to give your business the strongest legal foundation that we can, because we know that you're building tall and you're building wide. My second tip today, especially for those who are creating content, before you share any of your proprietary curriculum or your frameworks or your processes with any of your collaborators or contractors or potential business partners, you're going to have them sign the NDA. And so your NDA in this most basic form needs to cover what information is actually confidential and how the other party may or may not use it, and for how long or do they have to keep it confidential. And so you want to have all of this in it can be a one-page document that just makes clear that you are sharing a specific content and your expectation is that they keep it confidential. And so let's get that drafted up, and let's build in the discipline of every single time you have these important conversations that you have them sign an NDA first. Because we believe you're building something big. And so it's time to start protecting it is now. Build in that discipline at this point, because trust and legal protections are not substitutes for each other. Yes, we trust people, but we also are in charge of guarding things. And so these are the steps that we have to take to make sure we're guarding what we've been entrusted to. All right, so those are my two tips for this week. Get your one-page NDA done, and let's get the registrations that you need done this week so that that will be covered. Next week, because I know this comes up a lot, especially new entrepreneurs who are in transition. We're going to talk about going from a side hustle to actual enterprise. And it's a process. So we're going to talk about that next week. Until then, drop your comments below and let me know what's going on. And let's continue to build. All right. Have a great week.